Hello everyone, welcome back to another episode of Courts Today by Live Law, your go-to source for the latest and fastest legal updates. I'm your host Urvashi Chauhan, here to bring you daily developments, landmark judgments and significant rulings from the world of law. We start with the headlines and a concise overview of the top stories, and after that we delve into full details. The Supreme Court has set aside Kerala High Court's orders for disciplinary proceedings against Lakshadweep Judicial officer. A plea has been filed in the Delhi High Court to allow Sonam Wangchuk and others from Ladakh to hold peaceful protest at Jantar, Mantar. The Karnataka High Court has said that Bar Council of India cannot issue gag orders restraining speech of advocates or its members. The Delhi High Court has issued directions to prevent delay in releasing compensation to POCSO survivors. The NCDRC has held Greater Noida Development Authority liable for deficiency in service over incomplete construction. The Madhya Pradesh High Court has stated that state authorities cannot act as goons by dispossessing a person from their property and then not paying any compensation. And the Madras High Court has refused to interfere with the leasing 2.5-acre temple land for building a college. The Supreme Court has set aside orders for disciplinary proceedings against a judicial officer. A bench of Justices Rishikesh Roy and S.V.N. Bhatti was dealing with the case of a suspended sub-judge cum Chief Judicial Magistrate of the Union Territory of Lakshadweep. Against him, 2 petitions were filed by 11 convicted persons alleging that he, as a judicial magistrate, delivered the order of conviction without examining the investigating officer and without giving opportunity to the accused to cross-examine the witnesses. Initially, on 14th December 2022, the High Court adjourned the matter, calling for records from the court of CJM Amini Lakshadweep in a sealed cover. However, when the matter was next listed on 23rd December, the court passed orders directing the Lakshadweep administration to place the magistrate under suspension and ordered a detailed inquiry on his conduct as a judicial officer. Against this, the officer preferred 2 review petitions. However, the same were only partly allowed, substituting the Kerala High Court as the disciplinary authority to take appropriate action against him. Aggrieved, the magistrate approached the Supreme Court. It was contended that the High Court had directed suspension and inquiry even though records were requisitioned from the court of the CJM Lakshadweep on the preceding date and not received by the date when the order was passed. Going through the case records, the Supreme Court noted that the matter was adjourned by the High Court on 14th December 2022, with the tentative next date of hearing set in January 2023. However, this date was not reflected in the order. It called an affidavit from the Registrar General of the High Court of Kerala, who stated that as per directions in order of December, records were called from the CJM Court Amini Lakshadweep and the sealed cover containing records was received in the High Court on 26th December. As such, the Supreme Court observed that the records from the CJM Court were received in the High Court on 26th, but the order directing suspension and inquiry of the appellant was rendered prior to such receipt, that is on 23rd December, which meant that the records were not considered before passing the order. Accordingly, it was of the opinion that disciplinary proceedings against the appellant were initiated on the basis of a legally invalid order. So the top court overturned the orders passed in the review petitions and has asked the High Court to look into the case again. A petition has been filed before the Delhi High Court seeking permission to allow climate activist Sonam Wangchuk and his associates from Ladakh to hold peaceful protest at Jantar Mantar or any other suitable location from 8th October to 23rd October for raising environmental awareness and demanding 6th schedule status for Ladakh. The plea has been filed by apex body Leh, an organization working towards protecting Ladakh's cultural environmental interests. The organization initiated the march with approximately 200 Padyatris, including Wangchuk, and began the Padyatra from Leh to New Delhi. The petition was mentioned today before a division bench comprising of Chief Justice Manmohan and Justice Tushar Rao Gadela, which refused urgent listing for today but said that the matter would be listed tomorrow. Let me tell you, the organization is aggrieved by a letter issued by Commissioner of Delhi Police on 5th October rejecting the request to hold a peaceful demonstration at Jantar Mantar. The plea states that refusal infringes upon their fundamental rights to speech and peaceful assembly. It adds that the Delhi police failed to provide any valid or reasonable grounds for rejecting the request. If you remember, Wangchuk was leading the march which began in Leh last month when he was detained at Singhu border on the night of 30th September along with other people from Ladakh. They were released later on 3rd October. In the next update, the Karnataka High Court has held that Bar Council of India does not have the power to issue gag orders restraining the speech of advocates or even members of the Bar Council. A gag order restricts individuals or the media from publicly discussing or sharing certain information typically related to ongoing legal proceedings. The purpose is to maintain confidentiality and prevent any prejudice. The court allowed the petition filed by senior advocate S. Basavaraj, who had questioned the communication issued by BCI on 12th April this year. Basavaraj had filed a case against the chairman and vice chairman of Karnataka State Bar Council, alleging them of misappropriating official funds. The same was brought to the notice of the Bar Council of India, which in its impugned order directed the Secretary of the State Bar Council to promptly furnish all relevant documents, receipts and financial records pertaining to the expenditure incurred within 15 days. The Bar Council of India also authorized an audit to be conducted by a qualified chartered accountant. Pending the outcome of the inquiry proceedings, the chairman of Bar Council of India passed a gag order on all members of the State Bar Council or any advocate from making any further public statements or spreading any information related to the incident. The bench noted that the direction of the communication was not against any particular individual, but against the community of advocates itself. A single judge bench of Justice M. Nagprasanna said that the chairman of the Bar Council does not have the authority to issue a gag order that restricts an advocate's fundamental rights. Only a competent civil court or a constitutional court has the power to issue such orders, and the chairman cannot take over this authority, as was attempted in this case. The Delhi High Court has issued directions to prevent delay in releasing compensation by Delhi State Legal Services Authority to the survivors in POCSO cases. A division bench comprising of Justice Pratibha M. Singh and Justice Amit Sharma said that there is clearly a disconnect between the POCSO courts and the concerned Delhi State Legal Service authorities on this issue. The court noted that in several cases, even survivors with special abilities are not released the compensation, and in fact, the concerned DLSA is not even aware of the convictions which takes place. It thus directed the Secretary to hold a meeting with all the district legal services authorities and the concerned presiding judges of POCSO courts in each district to set up standard operating procedure in order to prevent the delays in releasing compensation. Further, the court directed that a flow chart be prepared explaining the manner in which communication from POCSO courts to the concerned DLSAs shall take place and how the concerned DLSAs, after release of compensation, would report back to the POCSO courts upon compliance. This order was passed in a criminal appeal moved in 2020 by a man in a POCSO case. This case highlighted the issue pertaining to timely releasing of compensation to the minor victims. The matter will now be heard on 9th December. Stay tuned. In another update, the National Consumer Disputes Redressal Commission has held that issuance of possession certificate without completion of project constitutes deficiency in service. In this case, the complainant was allotted a house on 120 square meter plot by Greater Noida Industrial Development Authority. After issuing letters for the execution of the lease deed, the developer demanded additional charges based on a court judgment that required Greater Noida Authority to pay higher compensation to farmers, which was to be recovered from the allottees. A lease deed was executed and a possession certificate was issued. But the complainant did not take possession and instead filed a complaint with the State Commission. The complainant sought possession of the house, compensation for mental agony, reimbursement for rent, nullification of demand letter, and litigation costs. The State Commission allowed the complaint and directed the developer to complete the building's construction and hand it over in a livable condition within 6 months. So the developer appealed to the National Commission, claiming that possession of the plot and house had not been handed over because construction was incomplete and the house was uninhabitable, making the possession certificate irrelevant. The National Commission has observed that the complaint was filed within the limitation period and the State Commission's pecuniary jurisdiction should have been capped at 1 crore. Since the claim exceeded this limit, the State Commission exceeded its jurisdiction. Therefore, its order was set aside. The National Commission dismissed the appeal with directions to the developer to complete the house, provide statement of account, compensate the complainant with 6% interest, and pay 1 lakh rupees as litigation cost. In a significant ruling, the Madhya Pradesh High Court has condemned state authorities for acting unlawfully by dispossessing a woman of her land and withholding compensation for nearly 17 years. The court emphasized that no one can be deprived of their property without due process of law, as the right to property is both a constitutional and a human right. Justice G.S. Ahluwalia said that the state could not act like goons by dispossessing a person from their property and then refusing to pay compensation. The case here involved petitioner Shashi Pandey, who had been dispossessed from her land without legal grounds, and despite previous court orders, the land was neither returned nor acquired. The High Court reaffirmed that while the Constitution does not explicitly mandate compensation under Article 300A, it is implied. And the state is bound to provide compensation for taking private property for public purposes. The court also highlighted the negligence of the authorities, noting that despite several years of delay, no effective action was taken to address the situation. In a scathing remark, the court noted the collector's misconduct and ordered contempt proceedings against him for flouting orders of the courts. The state has been directed to pay 10,000 per month in compensation to the petitioner for illegal dispossession from her land starting from 5th February 1988 until the land is lawfully acquired or returned. And lastly, the Madras High Court has declined to quash an order leasing 2.5 acres of land from Sri Somnath Swami Temple in Kolathur to Sri Kapileshwara Temple in Malapur for 25 years. The lease is intended for establishing an arts and science college. Justice M. Dandapani emphasized that the lease appeared to serve a benevolent purpose, stating that if the petitioner wishes to point out any irregularities, they can submit their objections to the appropriate authority. The petitioner T.R. Ramesh argued that the lease notification published in the Tamil newspaper Mallakar Kural did not meet statutory requirements under the Tamil Nadu Hindu Religious and Charitable Endowments Act of 1959. He claimed necessary approvals for the lease were not obtained. However, the special government pleader for the Hindu Religious and Charitable Endowment Department argued that the temple's executive officer had appointed trustees and asserted that the lease process would follow due procedure. The court ruled that the petitioner could submit his written objections to the department by 9th October and directed the department to consider these objections. For more details on the cases mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe to our channel. You can support us by donating through the thanks button at the bottom of our videos or by becoming a member at just 89 rupees per month.